Hello everyone, good to be here again. The topic for today is bail.
I know it's a very wide sounding and wide ranging topic, and it could cover various things. The following things: first, the principles and the guidelines for grant of bail. Second, provisions of bail under special statutes. Then, what do you need for a good draft, or what are the rules while drafting? And fourthly, I have drafted a sample bail application, and we will go through it pairwise and analyze what are the contents which are necessary to be in a bail application before a court of law. So these are the topics to be covered. We will come to the first one, guidelines for grant of bail. Before I go to guidelines for grant of bail, let us understand the concept of bail. It's very easy, really speaking. Bail is anything that whenever somebody is in custody, that person is required to be released on his own surety and as well as on the undertaking of another person, his friend, who will undertake to the court that he will try and produce the person granted bail before the court so that there is no hindrance to trial. Now, many of you may have heard the term that he is granted bail of rupees 15,000 or 50,000 or some figure. What does that really mean? That really means is that the person who stands as surety for the accused, he undertakes that in case the accused absconds, then he is liable to pay to the court that amount of bail. That is all that it means. And you need to show that the person who's standing as surety is solvent to the amount of rupees 15,000 or 50,000 or whatever the bail amount is decided by the court. So that is the concept of bail. Release on his undertaking before his guilt is adjudged finally by the court. Now, bailable and non-bailable offences. Again, non-bailable is, so to say, a misnomer, and though these terms are used several times in the CRPC, they are not really defined. Bailable means any offense where you are entitled to bail as a matter of right. There is no discretion granted to the court to grant or refuse the bail. And non-bailable, conversely, means that where there is a discretion to be exercised by the court for the grant of bail, and this discretion is what is important. Bail is granted under 437 or 439. 437 is applicable for magistrate courts. 439 is for sessions court and the high court. The limitations, there are certain limitations under 437 which are not applicable when the application is under 439 before the sessions court or the honorable high court. This is bailable or non-bailable. What are the circumstances in which you are entitled to bail? One is, of course, like I just said, when the offense itself is bailable. How do you know if the offense is bailable or not bailable? There is a schedule to the CRPC which classifies each offense and which will tell you whether the offense is bailable, not bailable, compoundable, if so by whom, and triable by which court. So in the schedule, you will get to know whether your offense is bailable or not. So yes, you are entitled to bail in a bailable offense. You are also entitled to bail when the police does not file the charge sheet within a certain period of time, and if you are in custody. So for offenses less than 10 years punishment, within 60 days, the police is required to file the charge sheet from the day that you are produced before the court. Thirdly, you may also get bail wherein you are in custody and you have served half of the maximum punishment and still the trial is not over. Then also you are entitled to bail as a matter of right. This part was easy. What about non-bailable offenses where the discretion comes in? So over several years, guidelines have now been established which are accepted, universally accepted. And these guidelines you see on the screen. The first being that the court granting bail should exercise its discretion in a judicious manner, not as a matter of course. So therefore, the court needs to look into all aspects and not grant or deny bail as a matter of course. Though at the stage of granting bail, detailed examination of evidence and elaborate documentation of the merits of the case need not be undertaken, there is need to indicate in the orders the reasons for concluding why the bail was granted or denied, especially granted if it's a serious offense. You must remember that at the stage of bail, only prima facie cases to be seen. The court should not hold a mini trial to see whether you're guilty or not, and that should be the consideration at the stage of granting bail. Third, necessary for the court to consider these factors A, B, and C. Let's look at A, the nature of accusation and severity of punishment in a case of conviction and nature of supporting evidence. So A itself has three factors. First is how grave is the charge? Is it a case of murder under 302, or is it a case of rash and negligent driving under 279? You see, they are both diametrically opposite charges, and therefore the nature of accusation and the punishment. By how many years is the offense punishable? These need to be seen. Thirdly, what is the evidence that the prosecution has with it to support its charge? That also needs to be seen by the court. Second, B, apprehension of tampering with the witness or apprehension of threat to the complainant. This is the second important consideration, that once you're let out on bail, are you going to behave yourself, or are you going to do something to thwart the prosecution case? Will you tamper with the witnesses? Will you tamper with the documents? Will you, any evidence which is available, are you going to do something to destroy that evidence is important. That is an important consideration. And thirdly, prima facie satisfaction of the court in support of the charge. What we spoke about earlier, that after going through the evidence, prima facie does the court believe that the crime has been committed by you or not. So these are the universally accepted guidelines for bail on which courts look at the case. But at this time, I must tell you that each case is dependent on its own facts. And though the guidelines are there, you cannot apply a straitjacket formula to any case. And every case of bail is dependent on its own facts. This is guidelines for grant of bail. Second is anticipatory bail. Anticipatory bail, if you try to search in the CRPC, the phrase is not defined. In fact, the word anticipatory is not used anywhere in the code. So therefore, I have culled out the subsection 1 of section 438. 438 is the section which allows the court to release a person on anticipatory bail. So I'll read out. It says, when a person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense. Please note two important things. When a person has reason to believe and non-bailable offense, he may apply to the High Court or the Court of Session for a direction under this section, and the court may, if it thinks, direct that in the event of such arrest, he shall be released on bail. So therefore, the phrase used is in the event of arrest. Even when we draft the application, we say that, therefore, in the event of arrest of the accused so-and-so, the court be pleased to direct that he be released on bail. Arrest is necessary because only after arrest does the concept of bail arise. Now, what are the other two preconditions in this section? First is reason to believe. This reason to believe has been interpreted by the court to mean a actual belief. It is not that you have a belief in your mind that, I may be arrested. You need to show something more than that to the court to say that, yes, there is this FIR filed against me, and therefore, basis this FIR, I have reason to believe since it is for cognizable offenses, I may be arrested. So that is what is reason to believe. Second precondition is that non-bailable offense, naturally, because like I just told you all, that in a bailable offense, you are entitled to bail. So there is no question of discretion. So it is only in cases of a non-bailable offense that you may go in for a pre-arrest bail or an anticipatory bail. And third, that this power is given only to the High Court or the Court of Session because it is higher than when you are in custody. You are seeking bail. Basically, you are avoiding the interrogation police interrogation. You are avoiding custody of the police, and therefore the power is given with the Court of Session and the High Courts. We discussed a couple of judgments on this. The locus classicus on this subject is a judgment of 1980 of a constitution bench of 5 judges, Guru Baksh Singh Sidhya. And I recommend that everybody must read this judgment, because though so many years have passed, it is still this judgment which we use regularly, because it makes for a very good reading, and it has laid out some of the principles which are now immortal. What does Guru Baksh Singh say? That since denial of bail amounts to deprivation of personal liberty, the court should lean against imposition of unnecessary restrictions on the scope of Section 438. You see, there are some conditions which are already given in the statute, that these are the conditions that may be imposed while releasing a person on anticipatory bail. The court here said that beyond this, you should be circumspect while imposing any further conditions. Second, it said 438 is a procedural provision which is concerned with personal liberty of an individual who is entitled to the benefit of presumption of innocence, since he is not, on the date of his application for anticipatory bail, convicted of the offence in respect of which he seeks bail. So this is what Guru Baksh said. It laid down some more guidelines. First one we already discussed, that the applicant must show that he has reason to believe that he may be arrested for a non-bailable offence. Second, High Court or Sessions Court may apply its own mind to the question and decide a case. Third, filing of a first information report is not a condition precedent to the exercise of power under 438. Okay, so now let me just explain this a little more. Generally now in our courts, practically, whenever you go for an anticipatory bail, you normally annex a copy of the first information report, because that puts it beyond any doubt that there is an apprehension, there is a real apprehension that you may be arrested. However, sometimes you may not be able to procure the first information report. The police can be quite cagey about handing that over, and normally they don't give it to an accused, though there are several judgments stating that FIR is a public document, and therefore if somebody applies for a certified copy, it must be given. However, in practice, so is not the case. So you may not be able to procure one. Or two, there may have been a complaint filed with the police and the inquiry must be on. However, the complaint is not yet reduced into an FIR. The police have not taken a decision whether they want to file the FIR or not. And still, even in that case, there is an apprehension. Therefore, the judgment clarified that the filing of a first information report is not a condition precedent. Practically, what the court will do in such a scenario is give you something called a 72-hour notice relief, wherein if at all later on, after filing of your anticipatory bail application, the police decide to file the FIR, then it must give you 72 hours notice for you to be able to approach the court once again with a copy of that FIR and seek your relief. That is how it is done. Saturday, Sunday is 48 hours. So, in case it's filed on Friday, you still have Monday to be able to approach the court. Anticipatory bail can be granted even after an FIR is filed, so long as the applicant has not been arrested. I think that's clear that once you are arrested, of course, your relief of anticipatory bail is infructuous, has no meaning, and cannot be invoked after arrest. Blanket order of anticipatory bail should not generally be passed. This is important, meaning to say that it should be relating to a particular complaint at a particular police station. So whenever you are seeking bail, anticipatory bail, it cannot apply omnibus to all the police stations or across the country or across the state. No, it will apply to a particular complaint filed with a particular police station. So either you give the FIR number or you say that a complaint made by so-and-so person. So you will get relief in respect of that particular complaint. So it cannot be blanket. Normal rule should not be to limit the operation of order in relation to period of time. Basically, that the anticipatory bail will extend till the end of trial, and it cannot be that it is only till filing of the charge sheet or anything like that. So that also this judgment clarifies, because there were several contrary decisions before this. So this is Guru Baksh Singh Sibia. Another judgment of more recent origin is Siddharam Maitre versus State of Maharashtra 2011, wherein the Supreme Court reiterated all the principles in Sibia and further clarified the parameters relating to bail, anticipatory bail. And it says nature and gravity of accusation, exact role of the accused, the same thing which we saw for guidelines for regular bail. Antecedents. What are antecedents? This is how many crimes is the accused previously accused of, right? So antecedents are important. They are important for regular bail as well as an anticipatory bail, because if a person is a habitual offender, then the court is not so inclined to grant him or release him on bail. Possibility of applicant to flee from justice, again, one of the guidelines in regular bail also. The logic is, of course, that you should be available to face the trial as and when trial happens, and the trial should not be hampered because you are released on bail and then you have absconded. Applicants' likelihood to repeat similar offences, or Supreme Court in this judgment also said that please see that whether the accusations have been made only with the object of humiliating the applicant by arresting him. So this was one important new addition to Sibia, wherein the Supreme Court said, please examine whether it's a false case, whether the accusations are only to arrest him and then to humiliate by the way of that arrest, or are the accusations really true? Impact of granting the anticipatory bail, wherein the offense affects a large magnitude of people, say an economic offense, wherein depositors have deposited thousands of crores with the accused. So in that case, the court said that you must look at the impact and whether the release affects what number of people the release affects. So these are some of the principles. Now I'll come to bail under special provisions. You see, IPC and CRPC were found to be short. With the nature of the offense changing and the complexity of the offense rising, it was found that the provisions under IPC are not enough, and therefore special laws came to be drafted. There are many now, as you all know, and in these special laws, not only the procedure but even the conditions for bail came to be altered, and we will examine one of those. The first law which really brought in these special provisions was the TADA, terrorist, which was drafted for prevention of terrorism and crimes related to terrorism. So TADA, of course, is now repealed, but let us look at the provision. Section 28 of TADA read as under: notwithstanding anything contained in the code, no person, so this is important, notwithstanding anything contained in the code, so therefore it gives a go by to the provisions of the criminal procedure code, and states no person accused of an offense under this act, so anybody who is punishable under TADA act or any rule made thereunder, if in custody, be released on bail on his own bond, unless a, the public prosecutor has been given an opportunity to oppose the application for such release, no difficulty there. B is what is different and so to say slightly draconian, wherein it says where the public prosecutor opposes the application, the court is satisfied that where there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. What are the things that the court needs to believe that a person is not guilty of such offense, and further that he is not likely to commit any offense while on bail? The limitations on granting of bail specified in subsection 8 are in addition to the limitations under the code or any other law for time being in force. Please see that it places a very, very high burden on the accused. First, it turns the proposition of innocence of presumption on its head, right? Because what is required here is for the court to believe that I am not guilty of the offense. We are at this stage of bail. There is no trial. There are no witnesses examined. court needs to only look at the material produced by the prosecution. Basis that, court needs to come to a conclusion that the accused is not guilty of the offense. So it is a very, very high burden to discharge. Second, that he is not likely to commit any offense while on bail. Now, this thankfully later on was interpreted to mean that any offense will not mean any other offense. It will mean an offense under that special act itself. That he is not likely to commit any offense while on bail. Again, does the court have the material or the material before it to come to such a conclusion whether the accused will commit such an offense again while on bail? So these twin conditions are there, and it's a very high burden on the accused, and it turns the presumption on its head. Though TADA was repealed, several other acts, this became a template for similar bail conditions in several other acts, and some of them that you can examine is Companies Act, wherein under 2126 for fraud, similar conditions are there. PMLA had similar conditions. UAPA, which is the Unlawful Activities Prevention Act, has similar pari materia provisions. MACOCA has similar provisions, which is the Maharashtra Control of Organized Crime. So these exist. The validity has been upheld in Vishwanath Shetty. The most important judgment here was Ranjit Singh Sharma, wherein these questions were posed by the Supreme Court. Ranjit Singh was in the case of Maharashtra Control of Organized Crime, wherein he was accused of an offense under MACOCA. And these are the questions which were posed by the Supreme Court in deciding the judgment. Whether this statute requires that before a person is released on bail, the court prima facie must come to the conclusion that he is not guilty of an offense. Correct? Because it is very difficult without holding a trial to come to that conclusion. Also, is it necessary for the court to record such a finding? And thirdly, would there be any machinery available to the court to ascertain just what I said, that once the accuser is enlarged on bail, he would not commit any offense whatsoever? So these three questions were posed, and the observations in Ranjit Singh are very important as they have become the norm for deciding bail applications in such cases. So I have culled out some of the observations which we will go through one by one. First, the court held that the restrictions on the power of court to grant bail should not be pushed too far. The court then ascertained role of the court concerned in grant or rejecting bail and its effect on overall trial. It held that, in our opinion, does not lead to the conclusion that court must arrive at a positive finding that the applicant has not committed an offense under the Act. If such a construction is placed, court intending to grant bail must arrive at a finding that the applicant has not committed such an offense. Such a scenario, it will be impossible for the prosecution to obtain a judgment of conviction of the applicant later on, right? So, court said such cannot be intention of the legislature. Third, if the court, having regard to the materials brought on record, is satisfied that in all probability he may not be ultimately convicted, order granting bail may be passed. Satisfaction as to likelihood of not committing an offense must be construed to mean an offense under the Act, what I told you, and not any other offense, minor or major. Culpability of the accused, and court at time of application shall consider application for grant of bail shall consider whether he was possessed of the requisite mens rea. Very important. And lastly, the rule for bail, the court must clarify that the duty of the court is not to weigh the evidence meticulously, but to arrive at a finding on the basis of broad probabilities. So you should consider the broad probabilities, and this is what is now used in deciding bail applications under these special statutes. Like I said, these similar provisions are there in Companies Act, in UAPA, in MCOCA, and the PMLA. When we talk of PMLA, of course, we need to see, it cannot be complete if we don't see the judgment of Nikesh Tarachand Shah, wherein the Supreme Court struck down these provisions, the section 45, which had similar provisions, and it struck it down on the ground of being discriminatory, arbitrary, and violative of Article 14 and 21. I have just culled out one para, which will give you an idea that Supreme Court said that if a person who's accused under this offense of PMLA If pre-trial arrest bail is granted to such a person, which ensures throughout the trial. We already saw, as per Sibia, once the pre-trial arrest bail is granted, anticipatory bail is granted, there is no time limit and it will continue throughout the trial. So if pre-arrest bail is granted, which ensures throughout the trial for an offence under Part A of the schedule and Section 4 of the 2002 Act, such person will be out on bail without his having satisfied the twin conditions of Section 45. However, if in an identical situation, Y is prosecuted for the same offences but happens to be arrested, then applies for bail, then he needs to meet these two conditions. This again leads to an extremely anomalous situation, showing that Section 45 leads to manifestly arbitrary and unjust results and would therefore violate Article 14 and 21. So, Nikesh Shah is again compulsory reading. It's beautifully written by Justice Nariman. He goes through the entire history of bail and what are the principles. So Nikesh Shah struck down Section 45. Later on, an amendment was brought. However, two high courts, Delhi High Court as well as the Madras High Court, have held that even the amendment has no effect of negating the judgment, and these provisions continue to be unconstitutional. So that was on the principles of bail and special provisions in special statutes with regard to bail. Now I will come to drafting and drafting of a bail application. First, we will look at the basic rules for drafting. Number one is formatting. And however simple it sounds, it is so important because you need to imagine a judge who is doing 50 matters a day and comes across your draft. So if it is not formatted, already his mood is not great, right? So formatting involves it being page numbered, having white margins, same font, using a proper font, and things like that. So formatting is very, very important. Second, of course, no spelling errors. Third, typography. Where are you using bold, underline? Which font are you using? Brackets. All this is really important. Please do go to typography for lawyers, and there you get invaluable tips on how you should ensure that your draft looks good. Fourth, simple language. When I was also young, and many young lawyers like to use flowery language, and it really looks good on paper. But over time, I have realized, and simple language is much more preferred. What you can say in half a sentence is preferred than you adding difficult words which you may not be able to pronounce. So a simple rule of thumb is whatever you have written, try and say it aloud and see how it sounds, right? So simple language is very good, and that is what you should endeavor to in your drafts. Short sentences, it comes with the same thing. Make your sentences short. Let it not be too long and winding so that you lose focus. Repetition. Again, I have seen in many of the drafts, you tend to keep saying the same thing again and again, that my client is innocent, that he is falsely accused of the offense, that there is no crime committed by him. 3-4 paras devoted to saying the same thing. It is not going to make it true, right? We all know that. What it is definitely going to do is irritate the judge. He has so much to read, and when you are repeating the same thing 3, 4, 5 times, it is just he's going to miss out on the real important parts of your draft, thinking that it is full of repetitions and this is what it contains. So therefore, please keep it short, please keep it simple, and one para is enough to say that my client is falsely accused, he has not committed this crime. It's enough. The judge has got it, right? No repetition. 7, 8 are connected. You need to narrate the events as they have happened. So that when the judge is reading your draft, he doesn't need to look at anything else. He doesn't need to refer to the other documents. And when he reads your draft, he is able to get the entire timeline of events logically, and he is able to follow the story. Ninth, you need to try and create an interesting story while drafting, and narrate the facts in a manner that appeal to the conscience of the court. So you need to, once you're drafting, or once your draft is ready, you see and read it, or make somebody else, a third person, read it to see how they follow the draft, and does the story appeal to the conscience of the court, right? At no point, please take this to mean that you will hide facts or distort facts or go anywhere away from the truth. And you just need to narrate them in a way that it appeals to the conscience of the court. Lastly, please revise your drafts, read them again and again. And like I said, ask your junior to read them, ask somebody else to read them to see how it has come out. So these are the basic rules. Now, when we come to special rules regarding a bail application, first, the good part is that they are relatively easier to draft than, say, any pleading in a civil proceeding, because therein you have to ensure a certain number of things. With a bail application, it is much easier. Second, say less. The less you say, the better it is for you in most cases. Third, no admissions, absolutely. They'll hurt you later on. Because whatever you state in the bail application, and you may get out on bail stating something, but later on during the course of the trial, that admission will affect your case adversely and will limit your defense. I'll give you a small example. Say it is a case of hit and run. While driving a car, the accused has hit somebody and the person is injured. So, and it was raining and the road was slippery, and there were no lights on the road, and therefore he could not see the person on the road, and therefore the person. So you, while drafting the bail application, very happily say that yes, the accused was driving the car. However, since there were no lights on the road, and it was raining and the roads were slippery, and therefore this accident took place. So therein you have admitted that your accused was driving the car. So it limits your defense drastically later on in the trial. Because one of the main defenses in a hit and run is that the person who is driving the car is not the person who's on trial. So it is for the prosecution to prove first in a hit and run that it was the accused who was actually driving the car. So therefore, you have to be very, very careful with regard to admissions. And therefore, to go to point two, that the lesser you say, it is probably better. Now, what I will do is, so that you all get a first-hand understanding, I will share a sample draft that I have prepared, especially for this webinar, with you. And we will go through each para so that you know what comes in which para and what is the importance of each of those paras. This is a sample bail which I have drafted for you, and this is before the High Court. And in fact, it's an anticipatory bail, but more or less the bail, regular bail application and an anticipatory bail, more or less will remain the same except in the prayer clause and few other provisions. I have taken a case wherein the accused is accused of an offense under 376 of rape. However, the defense of the accused is that the girl and the accused were in a consensual sexual relationship, and it is only later on, after the girl got married, that she has chosen to file this case for rape under 376. How that is made out is that the Supreme Court says that in case you have physical relations with a girl with a promise to marry her, but later on you do not marry her, then it would constitute rape. So there are many of these cases which are filed nowadays. Some of them are definitely false. And so I have taken one of those examples today. This above here is your cause title, from wherein you write the court before which the application is to be heard. Here you write provisions of 438 because those relate to anticipatory bail. Then in the matter of the CR number, so and so, so and so. Okay, so before you start drafting a bail application, you need to have a pen and paper and you need to note down certain things. One, you need to look at the FIR. What is your FIR number? What are the offences, sections? What was the time of the incident? What was the date of the incident? What is the date of the FIR? Who all are the accused? who is the complainant, age of the complainant, age of the accused. These all you will keep needing throughout your drafting of your bail application. If your application is after filing of charge sheet, then what is important is when there is a conspiracy and say 5 people are accused of the same offense, say a case under 302 where a murder has been committed and there are 5 people who have been charged. So you need to then show the court what was your exact role in the entire offense as alleged by the police. So then you need to see in the FIR where does your name come in, and by your I mean your accused name, and where if it is after filing of charge sheet, then in whose statement which witness talks about you and what is the role ascribed to you. Were you just standing there? Were you acting as a lookout? Did you help in procuring the weapon? So your exact role has a direct bearing on whether you will be granted bail or not. For example, in that same example, if the person has actually shot or knifed the victim, then the chances of bail become drastically lesser than a person who only arranged for the weapon, right? So exact role is very important before you start drafting. So you need to study your chart sheet very well. You need to have everything ready, and you need to have the other things which I mentioned, FIR number, so on and so forth, ready before you start drafting, so that your draft becomes much easier. Then thereafter, once you have said, here you need to say matter of CR number so and so, which is the FIR number, which police station, and which sections of IPC or other sections. Then the name, age, occupation, all very important. Not a matter of formality, and I will come to that. Why? Very important. Address. If it's a regular bail application, you need to mention which prison he is presently lodged at. Versus, it's always versus the state. You all know prosecution is conducted by the state. State of Maharashtra, and through Senior Inspector of Police, which police station, which city. Honorable Chief Justice, all this fine. Now we come to para 1. Para 1. I have said applicant is a young man aged 24 years old. He's holding a graduate degree in MCA, has his own business in the name and style of so and so. He's staying with his aged parents, permanent place of residence, roots in the society. Each of these sentences is extremely important, and it needs to come in para 1. Young man. This is important. Young is important because it is a young man. You don't want him to be with the hardened criminals who are already in jail and therefore, take to crime later on. So this is a persuasive argument before the court. He is educated. It is not that, he is jobless. He has his own firm. He is doing business. He is staying with his parents. Why aged parents? Because there's nobody else to take care of them. So this young man needs to be out so that he can take care of his parents, and he has his permanent place of residence here. So therefore, he will not likely to abscond because he has his place here, he has been here, so unlikely that he will abscond, and the applicant has roots in this society. So all of these to show the court that I'm not a flight risk and that I'm a young man, and it is detrimental for me to remain in jail for a long period of time, and therefore I be released. Second para needs to state what do you want. That you are approaching this court for seeking bail in the event of arrest in an FIR by so and so person, aged so and so, and the CR number, the FIR number, and sections, and which police station. Third, has there anything happened in the lower court before? Of course, if you are filing this before the lower court, then this para will not come. But herein you state that I had already filed for anticipatory bail. However, the same came to be rejected, and this is the order of the Sessions Court. Fourth, please read, case of the prosecution as alleged in the FIR is as follows. So, what we need to do here, and this is a mandatory para, that you need to translate the FIR as it is without adding or subtracting a single word from the FIR. Whether it is right, whether it's wrong, whether it's a typo, you need to print it, translate it as it is, and say that this is the case of the prosecution. Now, look at the word alleged, and I have highlighted as and when they appear in this entire draft, and they do many, many times. Because if you remember, I told you, absolutely no admissions of any kind. So this is precautionary. That this is the case of the prosecution as alleged. I do not admit it. This is what they are alleging. So I say case of the prosecution as alleged in the FIR is as follows. I say first informant is a housewife. She resides with her husband family in Nasik. It is her case in September. She was appointed as a manager with the help of her brother so and so. It is alleged that after some time she was introduced to the owner, who happens to be the applicant. Her office timings were so and so. Sometimes due to work of the company, the timings got stretched. Then she says it is her case. Again, you see this. This is the same thing as alleged. It is not my case. It is her case that because she did not like the work, she tendered her resignation. Then the owner applicant, who is your accused, came to know. He called her to the house. His sister was present. He said, "No, don't do this. Why are you leaving the job?" Then it is her case again that the accused ex used to call her on her mobile every now and then, often speak to her, though she did not like all this. And then the actual incident where she says that she was called after 6 p.m. And the accused told her that he has called another girl also. However, when she reached there was nobody else, and the accused tried to get physical with her. That the accused got physical with her, and therefore she has registered this FIR. Then you annex the FIR. Then para 5 is when you deny. And like I said, once is enough. Just because you say it thrice doesn't make it true. The applicant states that the allegation in the FIR are completely false and baseless, and the FIR is filed by the first informant only in order to escape from her own troubles in her marital life. True facts pertaining to the applicant and first informant as follows. Right? So you have denied the FIR. And now, this true and facts, sometimes you may not have, sometimes you may have, where you have and you have documents which are unimpeachable and do help your case, please do use them. However, if you are not sure, the documents are not trustworthy, please avoid, please stay away. They'll come back to bite you later on. True and correct facts. So here, I have taken a scenario where I do have, because if my case is that I was in a consensual relationship with the girl, then definitely I need to have some material with me to show that. So here I have said present applicant and first informant were in a close relationship, previously known to him. We got friendly with each other in 2019, became friends, started going out for dinner, watching movies together. They started liking each other, complimenting each other, were friends. Then they entered into a love relationship in the month of so and so, started meeting each other regularly. Right? Now, true love blossomed between both of them, and I had gone for a movie. So, herein I have said copies of photographs of movie tickets dated so and so, both of them in happier times, are annexed here too. So I can show, I have some documents to show, ki, see boss, we actually went out for movies, dinner together. So this allegation that has been put, there is some other circumstance to it, and it is not true. Further, what have I done? Applicant's company had given postpaid connection of the Airtel company of number so and so. Here too, annexed and marked as Exhibit F is a copy of email showing allotment of the said number. So first, I established that this number was of the girl and was allotted to her by the company. Then I say the applicant states that the call records of his number as supplied to him by Airtel show that constantly talk to each other on the phone for long periods, including at night time, much after office hours. So I can show from my itemized billing that 11 o'clock at night, 1 o'clock at night, both of them are talking to each other for an hour or more. So that clearly shows that if there was an allegation of rape, no girl would be speaking to her perpetrator at these times, and that too for such long periods over a course of so many months. Copies are annexed. So this is the defense that I have taken. Then some hotel booking, so on and so forth. You can add the depending on the material that you have. Now we come to the grounds. So finally, I say in para 14, because it's anticipatory bail, that the applicant is apprehending his arrest by officers of so and so police station, and therefore approaches this honorable court seeking bail in the event of his arrest, invoking section 438 of the Code of Criminal Procedure on the following amongst other grounds. Grounds are very, very important. They are the soul of your bail application. The court is going to look at, as you see from 1st to 14 is, except for the true set of events, is the prosecution case. Grounds is where you make out your case as to why bail could be granted. It could be in various ways. You could point out inconsistencies in the FIR. You could point out the material you have. You could point out that the section applied and the allegation made in the FIR don't fit with each other, and therefore also you should be granted bail. So let us look at a few of the grounds which I have taken. First is that I have not committed this offense and had maintained consensual relationship. So you see, in this, I have taken a bold stand and I have admitted to the sexual relationship because I was confident that I have more than enough material to show that the relationship was consensual. So this is a very bold stand. You may decide, like I said initially, you may decide to steer clear of the act itself and say that this is all false and there was no relationship and there was no physical relations and this is a completely false case. But here, because of the material, I have decided, no, let's go with it. We will deal with it in court. Second, FIR is registered after an inordinate delay of more than 3 years. Delay is very, very, very crucial. In any bail application, delay plays a major role, especially because delay leads to afterthought and delay needs to be explained. Here, there is a delay of more than 3 years, inordinate. The FIR is vague, devoid of necessary details. For example, in this FIR, I have taken that the date of the incident when actually the rape happened is not mentioned. So I have said the FIR is vague. The FIR needs to have particular details of things like this, that on which date did the incident actually happen. Inconceivable that the first informant continued to work at the same place for a period of almost 4 months after the alleged incident. Again, notice the word alleged. Material inconsistencies. F. First informant and time of alleged offense was of 27 years old, positioned to understand consequences of sexual relationship by giving free consent. So this is because there is some judgment of our High Court which says that when a person is an adult, he or she is very much conscious and understands the effects and consequences of being in a sexual relationship. The photographs which I used show that the parties were in happier times. Then KL, I have quoted 2 judgments. It is not necessary. And strictly speaking, judgments are to be avoided from your pleadings. And judgments are to be given across the bar at the time of arguing the case. But sometimes you may include them in your draft. And herein I have taken a few. The Honorable Bombay High Court in Kunal Mandlia, please read the judgment. It's fantastic. It's by Justice Mridula Bhatkar. So please do read this. Kunal Mandlia versus State of Maharashtra said that consenting adults indulging in sex relations are fully aware of the consequences and must bear results. And same is applicable to the present case. Another important, very important factor you need to show the court is cooperation. That your accused has been cooperating in the investigation with the police. What does that mean? That if the police have called you, you have visited the police station. If the police has sought certain documents from you, you have voluntarily and immediately provided set of all those documents required by the police, and so on and so forth. So here I have said falsely implicated, unnecessarily curtailment of rights. Applicant who has already cooperated with the police for investigation, there is nothing to be recovered from him. Hence, custodial interrogation is not essential. So cooperation needs to come out in your bail applications as many times and as many number of times that you have visited or given documents or whatever else you have done in order to aid the investigation of the police. Because if you are cooperating with the police, then I can argue that when I am cooperating with the police, what is the need of me being in custody? Lastly, some necessary grounds. You need to applicant undertakes that he will not tamper with the investigation or the evidence, that he is ready to visit the police station as and when required. he is ready and willing to abide by any conditions that may be imposed by the court. Naturally, when you are being released on bail, the court does impose some conditions. The conditions cannot be onerous, but can be in order to ensure that the trial is not hampered. That you do not have any antecedents. We discussed this, that no previous crime record, right? That's a big factor, because if you do, and if it is for similar offenses, chances of you getting bail are very minimal. And lastly, that I am a permanent resident of the address given above and I will not abscond. This is what a bail application requires. Quite simple, frankly, if you ask me. First, para your character, where are you from, educated, not educated. Then, what are you here for, seeking bail? Are there any previous orders of the court? What is the case of the prosecution? What are the true events, if any? And what are your grounds? Lastly, the prayer clause, very, very important. I always check the prayer clause first, and the court also checks the prayer clause first before going into your application. It needs to be very specific that this honorable court be pleased to order the applicant accused to be released on bail in event of his arrest. In CR number, you need to ensure that you have correctly taken the FIR number of your accused and not some other. FIR number of which police station, because each police station will have the same FIR number. So one of 2009 will be with Kolaba police station also, Kaparit police station also, and Gamdevi police station also, right? And for the offense punishable under which sections on such terms and conditions as this court deems fit and proper. So prayer clause A. B is interim relief, because what happens is it may take time for your anticipatory bail application to be decided finally. The interim relief will not be applicable for a regular bail application. But herein, there is a likelihood of arrest. So the court may say, all right, interim bail, till the time the police come, file their reply, and the matter can actually be heard. If you can make out a case that I should not be arrested tomorrow, so court may grant you a relief saying not to be arrested till the next date of hearing. So very important to have a interim bail clause prayer. And third is your omnibus clause, where you say that this court be pleased to pass any other order that it deems fit and proper. And this is also very important because many a times it happens that it may not happen in a bail application, but otherwise generally that the court may want to give a relief which you have not sought for, and then the court uses the aid of your clause C and grants you some relief which may not have been prayed for. Lastly, verification. Since it is an anticipatory bail, the accused is out, and therefore verification is required, wherein he solemnly affirms to everything that is stated in the application to be true and correct. In a regular bail application, since the applicant is in jail, verification is dispensed with and a verification clause is not required. So this is, we have gone through parawise of a draft sample bail application, and I hope it has helped you to understand what is required and what is to be avoided while drafting a bail application. With this, I'll conclude my webinar, and any questions I can take. Please explain bail bond, how is the amount calculated, and how to determine the exact value. No, the amount is calculated, the amount is decided by the court, Sachin, and there is no real formula to determine the value. It is based on the facts of your case and the gravity of the offense. For example, in an economic offense where the accused has duped thousands of crores, naturally the bail amount is going to be much higher. Bail bond is under 465 of CRPC, wherein the accused gives a personal release bond to the court stating that I undertake to be present for the trial, and this is my address, and I undertake to inform you if there is any change in address. Anticipatory bail is granted till which stage of proceeding trial would it remain valid? I think I've covered that in the webinar. It remains valid throughout the trial. Judgment of Sibia and judgment of Siddharam Maitre also. How to get bail in a non-bailable offense? What should be the grounds to obtain bail in a non-bailable offense? Covered in the very first slide, there are parameters for grant of bail. So I think that was covered. Can you shed some light on Safura Zagar's bail application being rejected repeatedly? 4-5 should taken under human rights activism. I think you're confusing a lot of 2-3 issues here. I have not personally gone through Safura Zagar's bail application or the case filed by the prosecution, so I cannot really comment on it. But the court which has denied bail would have taken all the parameters into consideration and denied bail. I think it is denied by the lower court, so definitely the application will now come up before the High Court, and you may have a different result there. That mean he's a repeated offender for ABA, especially when it is non-bailable but not accused. If a person is accused but not convicted, if a person is accused and not convicted, that means that he has not committed any crime. So no, he is not a repeated offender for purpose of a bail or an ABA. There are judgments to that effect which say that once you have been acquitted of an offense, it is as if no record exists. Okay, so you could look that up. Can a person become a surety for himself in cases of bail? I wish it was that easy. No, a person can't be a surety. The whole concept is that you have a person who stands as a surety for you, who undertakes to the court of producing you at the time of trial. On what grounds judge can deny granting of bails? I think you missed the first part. It was covered quite extensively. If there are more than one section under which an accused is booked, then for which section is the bail asked for? Bail is asked for all the non-bailable sections, including, but the consideration will be the one which is the most serious and which has the maximum punishment. It will be that section which will play the most important consideration before the court. Can an anticipatory bail be for specific charge by specific person or group of persons? No, it has to be for a very specific complaint only. Either a complaint or an FIR of a particular police station only. It cannot be a blanket anticipatory bail. Whether a person already in prison can file anticipatory bail if apprehensive about arrest in another matter? Yes, very good question. Yes, he can definitely file for bail, anticipatory bail, if he is apprehensive that he may be arrested in another matter. Yes, definitely yes. Is it possible to share sample of the anticipatory bail application? May I request a sample of regular bail application as well? I've already gone through the same, and yes, if it is possible, plea will definitely help you with that. Share important judgments relating to bail and anticipatory bail. Yes, as and when we do a session relating to bail and anticipatory bail, we definitely share these judgments, or even if I have some, I will share them with plea. Could you please throw some light on concept of parole? It's a topic in itself, parole and furlough, and we can do that sometime. But in brief, I can tell you, parole and furlough is granted while the person is already in prison, and it's like a holiday which the person gets for not more than 14 days in a year, and this holiday is counted in his sentence which he is serving. So this is after conviction, when a person is sentenced to a certain imprisonment, that you may avail of parole, wherein you get certain number of days where you can go and visit your family. And the logic behind it is that you stay in touch with the society, and it basically comes from the reformative aspect of punishment that we follow in India. If there is evidence of excessive force used by police while accused in custody which leads to serious injuries, whenever you are in police custody, you are produced before the magistrate at regular intervals, and at that time the magistrate will ask you if the police has treated you properly or has the police used any excessive force, and you can make a grievance at that time, and the magistrate will take necessary action. I think I've covered all the questions, and thanks everybody for attending. I really say that you need a great capacity to be wanting to learn and attend webinars and hear a person speak in monologue day after day. So thanks for attending. I hope it was useful.